Emma and Sam. Criminal law, we've got Grace and Vivian. And for real property and equity, we've got Sam, Nicholas, and Jay. And we've also are recording this session as well for anyone who wants to watch it after.
Okay, so if we're all good, we'll start it off, Ahan. So
Yeah.
To start us off tonight, we have Arasa and Nishta taking over Torts. So if you guys could just come in and just introduce yourself, and then you can get started.
Hi guys, yeah, I'm Arasa. I'm in my second year, so I did Torts this time last year.
Yep, hi, I'm Nishta. I'm also in my second year, doing an arts and law degree. Cool, should we get started with this?
Yeah, you guys can just take turns. Whoever wants to speak first can go.
Mm-hmm.
Okay, sure, yeah. Just starting off in terms of like my general experience with Torts, I thought it was like a really great time. It was a fun subject in terms of you get to deal with a lot of interesting cases and a lot of interesting issues. Obviously, it's your first substantive law subject, and I think it's a great intro because you get to do some like weird cases in terms of everyone has those iconic Torts cases that had these like wacky like facts that you kind of like always remember. It's like a deceptively sort of case law heavy subject. And obviously being your first like substantive law subject, you're going to be learning a lot of skills very quickly. And like for better or for worse, it's very different from foundies. So it's like, you're going to be learning a lot quite quickly.
Yeah, I agree. I think it's a bit of a learning curve going like from foundies to Torts. There's like so much content you have to do, like starting to do quite intense readings of your cases. So I think you become quite good at going through your cases very quickly at some points because it can be pretty dense reading at times. But yeah, like Arisa said, it can be like really funny. And I still remember lots of the cases we looked at in Torts. So that's always makes it like a really interesting subject.
Yeah, 100%. So I guess moving on to talk a little bit about how we kind of would recommend approaching the subject in terms of like study and like how to prep for it. The first thing I'd say is it's very, very important to do case summaries for all the cases that you read, because often you might read a case and you think, oh, I'll remember this. Chances are you're not going to, in terms of there's so many cases, and like you might, the moment you see that like case name again, you're not going to be like remember it as much as you'd like to. So case summaries are really important. I know there's a lot of questions on how you do those case summaries. The way that I always do them is you have your fact scenario at and then just so you know what case you're talking about. And then secondly, after you have your facts, you write down the main ratio that came from the case. So this is the sort of like law that's like applicable to like following cases and the main things that came out of it. The other thing that I would say is writing scaffolds is very, very helpful. And I wish I did more of it because it saves you a lot of stress at the end. And what I mean by scaffold is kind of like looking at how, like a scaffold of how the law as a whole kind of works together. Because I feel like when you don't do that, you're kind of looking at cases in silos and very discreetly versus when you're doing like a scaffold of like the sort of like overall negligence or like for like duty of care, right? It means you're seeing how the case laws sort of like interact and you're not just like seeing them like discreetly. And I guess sort of the last thing that I'd say that's like kind of different from like prep was I actually found doing the first year moot very, very helpful in that it is essentially like practice and it basically forces you to go like very in depth into an area of law. And I know for us, the first year moot question was on false imprisonment and assault. And then lo and behold, our first assignment was also on false imprisonment and assault. So like just plugging another SULS initiative, I found that really, really helpful.
100%. I agree with like everything Arisa said, especially having case notes, I think, because as I mentioned, it is very case heavy. I love using tables when organizing my notes, and I pretty much use that for all of my subjects. It's just like a really nice way of dividing up like the authority, the citation of it, and then all of your other information. You can split it up as you prefer. So as Arisa mentioned, like the ratio and the facts, all of that kind of stuff. I really liked having like quick mental like shortcuts as well for like cases because you do end up doing so many. So just knowing like the casino case or like the fireworks case, and you can just immediately be like, that's, you know, has to do with battery or false imprisonment. So I think just having those mental shortcuts is like really helpful when you start like doing encores during your lessons and your tutorials. And the second thing I would say is also like study groups. That becomes like really helpful as you continue doing law. Just having a good group of friends to discuss the content with in like a really useful way. You get to like see more nuances behind each case and the legal reasoning. And yeah, if I had like a third thing to say, I would also focus in your notes looking at the rationale behind judgments. I think that's something that starts to like differentiate people from like lower mark like responses versus higher ones, looking at not just like what the legal principle is, but some of like the normative values behind that. Why is that actually something that exists in the law?
And we've also got some questions for you guys sent in by students prior to this, and quite a few were related specifically just to torts. So thank you for all your answers that you're going to be giving us. So the first one, either of you can answer. So how should we approach note-taking for the subject?
Yeah, I'm happy to take that first. I also remember asking this question a lot in first year of how to take notes. I think, and often what I felt I was met with was a lot of very like vague answers. And like now realizing why you kind of got those vague answers is because note taking is very much like up to the individual. So like what I'm going to talk about is like what works for me. So what I like to do is like take notes for the lecture, like have separate notes for like the lecture for like readings and then what you do in the tutorial, and then kind of like synthesize that at the end of the course, just so like you kind of have those sort of like discrete things. In terms of like taking notes for like cases, like I alluded to before, the way that I like to do it is having the fact scenario at the start, just so you can remember what the case was really about. And then after that, dive into like the sort of like applicable law. But it is a lot of like trial and error and like what helps you remember it the best. So it is like learning what like helps you essentially, I would say.
Yeah, I agree. And I think it's also important to look at what assessments you're actually going to be doing during the semester. So if you're doing like a mid-semester exam that's coming up and it's based on, you know, like a short exam release, it's maybe not as important to be doing like heaps and heaps of scaffolds or like, yeah, like that, like memorizing as opposed to an exam. So I'm not sure exactly how they've structured it for torts this semester, but just being aware that your assessments should really be guiding how you do your notes. And I think that, yeah, like doing more work is always like better, I suppose. Like if you miss out writing out notes for like a tutorial, you're like missing some aspect of your learning in that sense. So even if it is a bit more work, something that was really useful for me when approaching problem questions is like normally every tutorial they'll give you like a problem set to do, and of course it's like not really feasible to do the problem set every single week, but at least if you have like a read over it or even attempt it like the bullet points, and then if you go into the tutorial you have a bit more understanding of what's going to happen, and then also writing down notes as other people on call are talking. That's really helpful in the revision stage, that you can go back and maybe attempt it yourself or have like basically some sample answers when you see what people on call have written. Yeah.
Okay, perfect. Thank you so much for those answers. Just going a bit more in detail about notes. So what were the things you made sure to include in your notes? Like, how did you go about collating them? Was there anything particular that you paid attention to?
I mean, maybe just like focusing like on the unit outline that's given to you, because that's like primarily what they're going to be marking you on, right? So if you go by like the subheadings in your unit outline, like according to like duty, breach, causation, or whatever, that's probably a good place to start, and then organizing your cases from there.
Yeah, completely agree with that. I really like my torts notes because it's a very clear subject. So you like essentially, you know, each element that you need to prove. And that's kind of like how I structured it, and I kind of like under sort of like each sort of main subheading, you kind of had this sort of, I had like this sort of general rule there as like a reminder, and then had like the relevant cases underneath that. And yeah, similar to what Nishta said, just like structuring it based off that. And yeah.
Perfect. Thank you. We've also got, if any of the audience has any questions to ask, feel free to like raise your hand or just like ask in the chat, or like DM us like privately if you want. But if that's all for Torts, thank you so much, Nishta and Arasa.
No worries.
We can move on to Torts and Contracts II now. So we've got Pat McGee, Alex, yeah. So just, introduce yourself and just take it away when you're ready.
Hi, everyone. I'm Alex. I'm an LLB 3 this year, and I did TC2 last year in my second year in semester 2. So I did it slightly differently to everyone, where I was in person, obviously, but I'm sure it's all very, very similar content, and I hope that some of the things that I learned on how to study TC2 can be used to help everyone else.
Yep. Hey guys, much like Alex, I did TC2 in last semester. No, you were last semester. Gosh, I've just forgotten that halfway through this year. I did it at the end of last year. I'm really sorry about that. You can tell my all day, but I'm a JD2. Again, very different experience to a lot of people having studied TC2 sort of in a blended half online, half in person with online exams. But again, hopefully, if you have any questions, I'm here to answer it and see how we go. But I think it's a relatively straightforward subject, and it should be a pretty good one to engage with.
So just going through a couple of general tips that I certainly have had in my time. I think the first thing that people generally wonder about TC2 is how much torts and contracts they need to remember from torts and from contracts. And in my personal view, and Pat, you're free to disagree with me and jump in if I've got it wrong, but I personally didn't find that I needed very much torts or contract knowledge to remember too much specific content from those subjects. More so, it's just about remembering the general concepts, like remembering what a contract is, remembering that it's something that people agree to and they take on responsibilities themselves, and remembering that negligence is the thing. And those sorts of very, very baseline concepts and remembering that they exist is pretty much all the torts and contracts that at least I felt was necessary to know, because everything else that you actually need to apply, they'll go through in all the detail that you need. And by going through that detail in the actual specific course content, it automatically brushes you up on all the torts and contract stuff. So in week 1, they make quite a big deal about making sure you remember everything from torts and contracts. But to be honest, I wouldn't worry too much about that, because everything you need to know, they'll cover in enough detail that you'll be able to pick it up. Is that something you agree with, Pat?
Yeah, massively. If anything, I think you're overstating how much you need to remember. If you need to know it, if it's assumed, it will tell you. Move on, engage with the actual subject that's in front of you, and don't get caught up in things from either torts or contracts.
Yeah. Another thing that I certainly found with TC2 is, so the way the unit works, if you're not familiar, is at least when we did it, the first half of the course is for contracts, and then the second half is for torts. So don't worry about feeling like you need to, have your contracts and torts brains on at the same time. You need to think about all this complexity as to how they relate together. For almost all of the content you're doing, it'll be either clearly contracts or clearly torts. So you can kind of compartmentalize all of it in your head without having to worry too much about deploying all at the same time, except for a few situations where maybe a contract and a tort might arise at the same time. So an example of that could be, if you're a doctor and the doctor is negligent, then the doctor might have some sort of duty of care over you as your doctor, and that's a tort, obviously. But you might also have some sort of contract with your doctor, if they're a private doctor, to ensure some sort of care is taken. So if they do something wrong in their treatment of you, that might be both a contract issue and a tort issue. But in those situations, you'll probably be able to recognize that both a contract and a tort could be involved. So in any situation where you're going to need to combine contracts and torts, theoretically, they don't really combine that much. The actual content that you're going through, you don't need to worry about the overlap between contracts and torts because it's either contracts or torts that you'll be dealing with. But given the subject deals with both, the only reason why you would need to be aware of both at the same time is because in some situations, there may be both a contract and a tort that's relevant. But apart from that, you don't need to worry sort of conceptually about how everything fits together like you might be worried about. Again, do you agree with that, Pat?
Yeah, broadly. I think I'll probably get into it a little bit later on, but my main piece of advice for this subject is keep it simple, don't overthink it, stick to the basics, have a very, very basic scaffold and go from that, and then dive into things later. And we can get into that later in the call. But everything Alex said is bang on with that. Don't confuse yourself. Don't overthink things. Just know your basic principles and make sure you stick to them. It's not hard. People make this subject far harder than it has to be.
Yeah, I definitely agree with that. I actually think so. TC2 definitely has a reputation. And, you know, for those of us in LLB, it is something you either do in second or third year, but for those of us in the JD program, it's something you do at the end of your first year. And because of that, it sort of seems like it's almost like the final boss of the semester or the final boss of the year, or, you know, the final boss of the non-all law period of an LLB's life. So people definitely make it out to be a lot easier than it is, so much so that I'm pretty sure, if I remember right, in the introductory lecture for TC2, they have a whole slide on why people tend to find it difficult. And that can obviously scare you, but in my experience, at least, I didn't find it too different in terms of the difficulty or amount of content. Maybe there's a little bit more content than in some other subjects, but as long as you focus week to week, like Pat said, on you know, compartmentalizing, what am I learning this week? What new thing is coming up this week, and focusing on that. If you just do that one at a time for each week, eventually you'll get to the end and you'll have a pretty good grasp on everything. And yeah, I don't think there's too much reason to be as scared as people often are. So that's certainly a plus, and hopefully that's a word of comfort.
I will just say that my videos had to drop out because of my internet speed, but I'm still here. I'm on board.
But yeah, I totally agree with what Pat said about how you try and, even if things are explained in a complex way, usually there's a simple way to kind of think of it in your head. And the more of those simple ways you can put it in your head, the easier it will be for you to understand it as a whole. It's a subject where you can sort of think of it as two separate subjects that you're applying in a problem question together. So the first half of it is all on contracts, and that's kind of like a contracts 1.5 subject on its own. And then the second half of the course is on torts, and that's sort of like a mini subject on its own. So as long as you think about how everything in that half of the course fits together as a whole, then that can be a really good way of making sure that you're broadly understanding everything and where it fits. And one tip that I found, and I'm sure Pat will agree, is the more, and this is probably true for all subjects, but the more you talk to it with people and the more you sort of understand, the more people you involve in your study, the more people you talk to, the more people you have explain things to you, often they will, or one of them will explain something in a way to you that no one has explained it before. And that just happens to be the way that you needed to understand it and for it to click in your head. And sometimes a tutor, because they're trying to cater to everyone, explains it in a way that works for the lowest common denominator. But I'm sure we've all had those experiences where we just can't understand something and we feel really dumb because everyone else seems to get it. But it's not necessarily that you're behind or that you're not as smart as everyone else. Sometimes you just need it to be explained to you in a different way. So if you have even a small group of friends who are taking the subject with you, even something like just a half-hour debrief each week or an hourly debrief each month on all the content you've gone through and having it explained could be really helpful.
Perfect. Thanks, Alex. Pat, do you have anything to add?
So my internet did drop out for half of what Alex said.
All I talked about, Pat, was just about studying with other people so that they might be able to explain things in a way that makes more sense.
Okay, yeah. So in that case, then what I would really strongly recommend, and I know it's really general advice, that me and some friends found it incredibly helpful for TC2 in particular, was just get a group of 4 or 5 of you, or really however many friends you have, but 4 or 5 is a really optimum number for a group dynamic. and just scaffold the problem questions independently every week, get together for a quick 1 hour call together and just compare and see where your points of difference are. Most of the time it's going to be the same for everyone, but then in those few occasions where you do have those points of difference, that's almost a signal for everyone in that group that that's a real area of contention or confusion or an area of unsettled law. And that's your prompt to sort of go and study further from that. Alex, did you see that we've got a few questions that have come in the chat? Should we touch on those now, or?
That's a great idea. Why don't we go through one by one? So starting with yours, Sanam, as to which topics required extra time. Is there a concept that was particularly difficult? Everyone will find different things difficult. In my personal experience, I thought the course just generally became more difficult as it went on in the year. So the stuff that you start with, like contracts damages, that will probably be the most difficult if numbers and maths and complexity like that are things that you don't really like in your subjects. But I actually think the contracts portion of the course, the damages bit right at the start, is easier. And this comes back to what Pat was saying. It's easier than people make it out to be. You don't necessarily need to be a maths wizard to be able to get it. All you need to know is the types of damages. So bargain damages, disappointment and distress, reliance damages, all those sorts of things. Know all the different types and then know all the general rules on them. So you can't double count damages. Try and put the plaintiff in the position they would be if not for the breach or the breach of contract. And once you know the types of damages and the general rules, in a problem question, one thing that's really helpful is to actually make up some method of calculation and come to some sort of figure. You don't have to do it complexly or any sort of difficult maths involved, but at least come up with some plausible way of calculation that could give you a potential figure as to what the damages could be. So that's probably a tip for the damages bit. And then with the rest of it, sorry, Pat.
I might just jump in there just quickly because I don't know how our semesters differed. I would stress to everyone, only give a figure if the question asks for the figure. If the question asks what damages are available, just name the kinds and the classes of damages and how they relate to each other, which ones you could claim, and leave it there. Because the feedback on both our assessments for my semester was that a lot of people unnecessarily did that work and they spent a lot of time on it and they missed out on a lot of marks. That said, what Alex is saying, I think, is really helpful to conceptualize how those damages work. And if you're able to do that, then you can definitely understand them. But just make sure you don't go beyond the question, because I think 30% of the people who sat our assessments got pulled up for it. And you really don't want to, again, overthink things. But that's all from me.
I especially agree with Pat because of the word count rule. I think the word count in TC2 is probably one of the hardest things to get around, as you might have found in previous law subjects. So doing unnecessary work is definitely something I could not emphasize and agree with more. So that's the damages bit. For the rest of the course, for me personally, the main content tip I found for the rest of the course was a lot of it is about making subjective judgments based on the vibe of the facts. And what I mean by that is when you're getting into things that make a contract invalid, like undue influence and unconscionable conduct, there isn't necessarily a list of exact examples as to what those things are. It's more of like a vibe of what satisfies the test and what doesn't, that you get by reading the cases and understanding the decision and the facts that led to that decision. And then when you see in the problem question similar facts, that's your cue to be like, okay, I'm automatically leaning towards this side of the answer because I've seen this fact pattern before in a case. And even if it is a completely novel fact pattern, it makes it a lot easier for you to make analogies to justify them, because really it's just about justifying your answer. Very rarely are you going to be completely wrong if you know the course and you know the content. So if you have a case of facts, one, that is very helpful in being able to automatically know what side to come down on an issue. But two, even if you don't know, it gives you something to analogize to justify your decision. And that in itself is probably enough to get you the marks that you're looking for. That's my main content tip for TC2 as a whole, to be honest.
What about you, Pat? Was there a concept that...
I guess to me...
That's fine. I think you're back.
Can everyone hear me all right? Or is there a lag on
you're good
my
now.
end? Okay, good. Sorry, I just wasn't sure if it
That's
went
okay.
again. So what topics required extra time? Was there a concept that was particularly difficult? No, because as Alex says, it depends entirely upon what you find challenging. You might find damages really, really tricky, and you might find pure economic loss the easiest thing in the world. it's entirely up to you. Just as I say, if you work through the problem questions in a very general, loose scaffold sense weekly, you'll very quickly know what those areas are well ahead of time of the exam, and you'll be able to invest that time in them. Personally, and I think this is why I say don't overthink things, because it was a really key lesson for me, is I loved the material on penalties. And I thought it was so interesting. And I spent all this time diving into unresolved law, and like these additional journal articles were there and doing all the extra readings, because I just found it really captivating. And several of my friends did. And then we got in the mid-sem, and there was a small, tiny, probably 5% of the marks on penalties. And I ended up writing, 20% of my paper on it and lost a bunch of marks, because in my head, it was this very unsettled area of law with all these weird nuances and niches. But in reality, the vast majority of penalties are very clearly settled, or at least there's broadly guiding precedents on most of it. So what I really struggled with was overthinking things in a few instances. And having had that experience in the final, I was very tight about making sure when I used extra readings and when I didn't, and when I just sort of kept to the bare minimum in terms of my loose scaffold, and then pulled in all that extra material from the readings in analogies and from the cases. And that's where you're going to get most of your marks, as Alex says. But it's really up to everyone. Ashwini, did you want us to move on to the next question? Because I think we can hit that pretty quickly.
Yeah, the question by Erica. Yeah.
So Erica, for everyone, do the problem questions in the mid-sem and essay mix torts and contracts, or is there a separate problem question for each? Look, in the mid-sem, it will just be the topic you cover first, presumably. In the final, it will be mixed in that the fact pattern will be bringing it up, or will be bringing both up for each question. However, when you're advising your clients or you're answering the question, you will only really be dealing with contracts in one part and then separately torts in another part. And then maybe there's a question at the end where they come together in one or two small areas of the course, but really they are quite separate. Alex, is that your experience as well?
Yeah, I completely agree. As I said earlier, in our final exam, and we might have actually done our final exam at the same time, Pat might have been doing the same one, but they actually specified sub-questions for each of the big questions that isolated exactly what they wanted you to talk about. So they might say, give reasons why this contract could be invalid, and then you're only talking about contracts. Or they could say, what causes of action does this give rise to? And obviously that is a bit more general, but generally you're only covering breach of contract and a bunch of different torts. And that's all the cause of action you need to know. So as you do the course, you'll get an idea of what is separate to other concepts in the course and what could come up in the same fact pattern, and then you'll get a better idea of it as it goes on, I think. As to this, and what Sam just put in the chat is very good as well. So some scenarios will have a torts claim, a contracts claim, and statutory claims under the ACL. And the statutory stuff will become clear as you go on the course and you actually learn that sort of stuff. It's kind of like an addition to contracts in the way that it works, I think. But usually it'll cover both parts of the course and isolate what to talk about in each specific sub-question. So very quickly on Isha's question. Yeah, so you're absolutely right that in damages, and particularly Pat was talking about penalties and things like that, there's also a lot of unsettled law and penalties. And another place I found there was a lot of unsettled law was purely economic loss right at the end, where there's a bunch of different tests. And the core of all this uncertainty is that at a lot of different places in the course, there'll be multiple potential tests to apply to a fact pattern, and you're not sure which test is the preferred one. So my advice is whenever there's a situation like that, pick one test that's your favorite, justify why it is, and that's the key point. Have a sentence that explains why you're applying that one over the others. Maybe it's the most recent one that's been applied. Maybe it's the one that has the most cases behind it, et cetera, et cetera. And then, or maybe it's the one where the case that applied it was most similar to the case, to the fact pattern that's being used right now. Just have a reason why, and then analyze the facts based on that test and the cases that apply that test. And then if you have time, have a second shorter bit, which says if the alternative test is applied, here's the likely result. And that pretty much ensures you for everything. Because as we said earlier, it's not necessarily about getting it right, especially when the law's unsettled. But if you say the law is unclear and here is why I'm preferring this test and here's the likely result, that's pretty much all you can do as a, you know, as a young adult who's learning the law. That's really all you can do.
Perfect. Thank you so much, Alex. Pat, do you have anything to add? Anyone, any extra final questions just before we jump to the next segment?
Look, I'm not sure what I missed again when my internet was spotty, but I would say one of the biggest pieces of guidance I have for people doing TC2 is just make sure that you follow the right path. And so when I say that, is that when you have two alternative and mutually exclusive options that you're going to pursue, and you'll know about this quite far in advance, because when you look at them, they'll be paired together, right? You might have negligent misstatement, and then you might say have professional negligence if you're being advised, say, by an accountant or a lawyer, and that might come up in a fact pattern. You need to know in advance exactly what is going to take you down one path versus the other, because that is a very common problem that people have. And it's pretty easy to do. Just make sure you have that in advance. And I think the only other thing I would say is this subject, at least when I did it, the lecturers were really good in providing you with a general scaffold. Have that. Do not change it. Don't mess around with it. Don't add steps. Don't confuse yourself. Use that. And then, as sort of sub-issues underneath all of them, have all your analogies, have all your cases, and that's where those marks are again. And yeah, as Sam said, some teachers give you a slide at the end of the scaffold. And I kid you not, that's what I used in my final exam. Ours was a long release 48-hour one, and then I sort of dived into my notes for the rest. But just don't overthink it. It's a really interesting, engaging, wonderful subject. Feel free to message me anytime if you have issues. I'm happy to help out. But yeah, it's a pretty straightforward one and really engaging. So just enjoy it, and don't get too caught up in the nuance, because that's where you can get caught up.
Perfect. Thank you so much, Alex and Pat. We will be jumping to the next section. Finish just in time. Okay, so for public law, we will have Alison Chen, Amir, and Sam. So go ahead, introduce yourself, and feel free to start.
Fantastic. Should I start us off? Thanks, Ishvini. My name's Amir. I am a JD3 student, and I really enjoyed taking public. It was one of my favorite courses, and I'm here to answer any questions that you may have. I'll speak a little bit about why I love public so much in just a second, but I'll let Alison and Sam introduce themselves first.
Sure, thanks, Amir. I'm Alison. I'm an LLB4 student. I as well also really enjoyed public law. It was one of my favorite subjects, and yeah, I'm here to share my tips and experiences with it.
Thanks, Alison and Amir. Hey everybody, my name's Sam. I'm also an LLB4 student. And I absolutely love public law. It was my favorite law subject that I've taken at uni so far, and hopefully can provide a perspective on why I loved it and how you can do well in it.
Cool. Well, I'll talk a little bit about my experience, if that's all right. The reason I love public law so much is because I think it's one of those courses that is a really good introduction to how the law works generally. Obviously, public law being, the law being created in Parliament and so on. You have a really good sort of understanding and introduction to the types of, looking at the Constitution, for example, the types of judicial powers, the types of executive powers, which are really important. I would look at it from the get-go as an introduction to constitutional law. I think that's a really good way to view it. So if you do want to do well in two subjects, it's important that you do well in public first. So you get a really good breadth of understanding of when it comes to constitutional matters, and especially if you want to focus on chapter 3 of the Constitution, which comes with the judicial matters and how the courts work. A good recommendation, I'd say, just broadly speaking, when approaching the course is, I sort of found that the course was split in half, and the first half is very much historically based. So there's a lot of historical context for you to understand how public law works. It's not so it's a bit different to other courses. You know, we've spoken today about torts and contracts too. And although these courses provide some sort of introduction to those respective courses, there's a lot of theory in public law. So it's really important to grasp that theory from the very beginning. Towards the second half of the course, you'll get a lot of structure as well. So I think it's quite important to view, at least I found, to view it to some extent as a checkbox activity where you're looking at, for example, things like matter and form. You have to go through all the different steps to make sure that you're filling out the problem question right. And in trying to, I guess, putting your notes together now at the beginning of the semester, just consider the first half of the semester as a lot of theory, approach it as such. So when you're putting your notes together, just write, this is what I understand, read the material, and then try to write it in your own words to make sure you understand it. And towards the second half, make sure you're putting in those specific steps that when you're then fulfilling or writing up a problem question, you make sure you check those steps while you go through the problems. Alison and Sam, do you have anything to add on that note?
Oh, I might jump in. Yeah, I definitely agree that public really sets you up well for constitutional law as well as admin law. I think in particular what I found challenging was chapter 3 courts. So that's topic 9 of the course, where you talk about judicial review, you talk about how the different courts work and interact with each other, ways in which people can obtain reviews. And for me, I found that in the whole, most of the course is very well structured and very sort of easy to follow as a bit of a scaffold, but topic 9 was definitely something that took a long time to understand. So if there's a topic that you want to really particularly focus on to do well in the final exam, for example, I would definitely recommend doing the readings, especially in topic 9.
Yeah, I'll just jump in. I think similar to Alison and Amir, I really like this subject because it kind of introduces you to a different way of legal thinking that introduces more kind of political, governmental, even moral and social questions than your typical contracts or torts law. It really is a good introduction to kind of public and administrative law. And for me, I think I really enjoyed the course because I was interested in those subject areas more so than anything else. Recommendations in particular, this course introduces you to some of the major landmark High Court cases in Australian legal history, such as Tasmanian dams, Boilermakers, Waterside Workers Fed. So honestly, just go through, do the readings and soak it all in. You'll learn as much from the historical side of the course as through going through public problem questions. So yeah, really take it in and try and get immersed in the legal world of public law, which is probably quite different to most of the courses that you'll have done up to this point.
Yeah, thanks guys. We've got a few questions. So as Alison just said, so you had some issues with topic 9, was it, with chapter 3 of the Constitution?
Yes.
Were there any other difficulties that any of you had with this topic, like specifically?
I think the main challenge of topic 9 is that it doesn't fit neatly into a process-driven scaffold, if you like. There's so many different subjective characteristics that affect, whether judges are prejudiced, whether things that are presented by defendants are actually, admissible comments. And so I think in particular, topic 9 is almost a bit more similar to your other sort of law courses where it's very much focused on the case law and you really apply that case law in a situation. Whereas with other topics in the course, I definitely found it a lot more contextually grounded. So not only was it important to know the case law, but it's also really important to know the policy considerations, the historical considerations at the time, what led to particular reforms being made. And so I think in that sense, topic 9, I found at least was quite different to the rest of the course and made it a bit more difficult to grasp.
And Amir or Sam, what were the difficulties for you, would you say? Would you agree with that topic 9 as what we should be looking out for, or are there any other issues that came up?
Sam, do you want to go ahead first?
Yeah, Alison, refresh my memory. Which topic was topic 9?
Judicial review. So it's all of the stuff about constitutional safeguards, judicial power, the things about, the cases like institutional independence, why, who, all those difficult persona designata, all those difficult cases.
Yeah, I think in particular in that section, probably the cable principle is good to go over because it's a bit different to the rest of the second separation rule stuff. And apart from that, I think probably just getting your scaffolds in place for all of the stuff around the GIPA and Freedom of Information Act. It's not conceptually hard, but you just have to get all the steps in place. So make sure you've got a good scaffold in place for the exam.
Just to add to that, I think I completely agree with Sam. I think, and with Alison, I think that specific section that Alison was saying is quite difficult to understand at first glance. But for me, what I found more challenging was definitely the section on open government and executive accountability. So looking at it, it's really important actually when looking at public, I think I guess it's important to say this, that things could be very different depending on what jurisdiction you're looking at. So making sure that's very clear in your notes is really important as well. So if you're looking at Commonwealth, for example, for a problem question, and usually the final exam will have one question that's Commonwealth related and another question that's state related. So for example, if you're looking at Commonwealth, you'll be looking at the specific act when it comes to the Freedom of Information Act for disclosures of public accountability, for example. Whereas in New South Wales, you'll be looking at the GIPA Act. And there is quite considerable differences there. So it's important that you have that easy and accessible for you to look at while you have your exam.
We do have a question from the audience, so we'll just jump into that. So William asks, how important is it to remember the content for the historical part of the course?
That's a good question. I think for examinations, not so important. However, and there's a big however here, it's really important that you understand the historical bits in order for you to do well in the course. I mean, there's no point in you trying to sit a midterm examination where, sure, the main bit might cover matter and form, for example, but there'll still be questions on your midterm examinations that cover the historical aspects. And if I'm not mistaken, well, at least when I did it, it was a multiple choice examination for the JD cohort. I'm not sure if it's the same. How did you guys do it? I'm not sure.
Yeah, no.
I
think when Sam and I did it, it was an essay and a problem question for the midterm. So I think it was like a short release, like 48 hours or a week or something like that. I don't remember how long it was, but for example, our essay was really focused on treaty and voice. And so I guess understanding the social considerations behind that was really important. And I definitely think the historical part may not necessarily be examinable in like the final exam in a problem question per se, but it's really important to understand those relationships between, you know, pre-Australia Act, post-Australia Act, how the different constitutions developed, the relationship between the state and the federal government and things like that.
Yeah, I might also add that starting with public law and moving more so into constitutional law, the mode of legal reasoning is very much tied to history and context and different theories of the law and theories of constitutional interpretation. So it's really important to have that historical grounding when you're making arguments in a problem question as to why one particular mode of interpretation should be preferred over another one too.
Yeah, that's true. I also would like to add that just remembering my final examination, I actually made a few points referring to the historical developments, and I got extra marks for it. So don't discard, just because you're resolving a problem question, it doesn't mean that development, the historical development of the law won't apply. I think it's seen very favorably that you understand how that has come to become the law in Australia and how that has changed, say, from imperial acts from the UK to becoming, constitutional law in Australia. You've got more questions. Actually, there was a question that someone asked, I think, before they submitted a question about how to reduce some information. Correct me if I'm wrong, Sanem and Farhan, but I think there's a question about how do you reduce all the content, so many readings in public law to your notes. And if I can just, speak a few words on that, I would probably say the easiest way I found to do it was simply just investing the time to read it. Make sure you don't, I mean, it's easy, especially when you're doing the historical stuff. You're like, oh my gosh, this can be so dry and so boring, but that's okay. Just sit down and read it and try to reread it. And then, as I said earlier, just try and rewrite that in your own words. Don't copy and paste stuff from, you know, your readings. That's not going to serve you any good, really. Try to rewrite it in your own words, and that way you'll ensure that you understand, especially the theory. That's such a big component within public law.
Perfect. So we'll just jump to the next question. So the next question has a bit more focus on note taking. So how did you collate notes for this specific unit? Was there anything that you particularly found to be helpful? Any one of y'all can jump in.
I think with notes, it's really important to pinpoint which things are state legislation and cases that apply to state and which apply to federal. I think a really good example of this is with relation to disclosure of documents. So at the state level, you're looking at cases like Egan and Chadwick, Egan and Willis, very much common law based cases, whereas at the federal level, we're looking at the Constitution, Section 7, I think. So making sure that you really distinguish between those two in your notes. I don't think it necessarily means you need to have separate scaffolds for example, like state and federal. I think you can keep it on the same scaffold, but just making sure that you distinguish between where your sources are for each of those steps.
Yeah, I would also say that in particular for public law and, you know, moving forward, administrative and constitutional law, it's important when reading cases to try and figure out what particular judicial method or interpretation particular judges will be taking. When it comes exam time, they're looking for you to kind of apply and analogize with particular rulings and particular, you know, quite famous and influential judgments. So having an understanding of why a judge is trying to say something, particularly in public and constitutional law, is really important. And when you're doing exam notes, keeping track of which judge said which particular thing and why that's important to the case will be really helpful.
Yeah, no, I completely agree with that. I think some of the best points that you can make in an exam is exactly what Sam just mentioned, is differentiating what judges have said in different cases. So for example, a good case you'll cover within public is the Dams case, and you'll see that the different judgments in that case, although they can look at first instance to be quite similar, they're actually very different. So being able to pick out and say, oh, well, this justice said this other justice said this, but I think, you know, applying it to this factual scenario, this is what the outcome would be like. So yeah, that's really important to just make sure, as any other course, make sure you have very clear and accessible notes, especially in an exam if you don't have enough time to look through it. The thing with public law is that you're not only looking through case notes, right? You're also looking at legislation. So just be careful. Although there's not much, I mean, you'd expect there to be a lot of legislation, and there really isn't that much compared to courses like admin and FedCon. But having said that, I think it's important that you do have that summarized very succinctly within your notes so that it is quite accessible when you sit for your examinations.
Thanks, guys. So Sinem's also just asked a question in the chat, and it may or may not relate to public law this semester, but how would you approach a research essay for public law as compared to like a problem question?
I don't know if any of us did research essays when we undertook the public law course. So I don't know if we're best placed to answer that beyond just general research tips.
I'll just jump in. It looks like the LLBs and JDs are going to be doing a short essay question and a problem question. What advice do you guys have for them approaching such an assessment?
Okay, I can try and take that one. I mean, I agree with Alison. It's a bit tough since we haven't really done that for this course. Looking at what we've done in other courses for admin, for example, where you do write an essay, and I guess also relating a bit of what I currently work in government, so looking at how to sort of address a problem question there, I'd probably say the best way to do it is something that Alison sort of foreshadowed earlier, is make sure you have the right considerations, not only when it comes to the law, but also policy. When you're writing in, especially when you're reviewing stuff with public law, there will be several policy considerations. So for example, if you're looking at a question that talks about, I don't know, the age on the right to vote, for example, say the question says the government's trying to, of that specific federal government is trying to change that and what needs to happen for that to take place. Well, if it is a constitutional arrangement, then a referendum would most likely take place. So think beyond the actual law and the written word of the law. What other policy considerations does that government would need to take into account is what I'd be thinking for in order to write an essay. I hope that helps.
Yeah, I think Sam and I did the same assessment, which was we did have a short essay based on class content. I think in preparing for the essay for the midterm, you don't need to do extra research. That was my experience. What's probably best is if you go through the first 4 or 5 topics that are going to be examined, there will be key issues that that the lecturers and tutors will focus on, whether they be about the Voice Treaty truth, whether they be about voting rights, whether they and the age of voting eligibility, things like that. So really pinpoint those 3 or 4 big policy issues that aren't necessarily always grounded in case law and are more concerned with how the different branches of government interact with each other, how members of parliament interact with constituents and all of those elements as well. And really invest the time to do those readings that aren't always just the cases for those. And I think that will really help in terms of preparing for that essay.
When I did the course, it was actually still multiple choice. I think I must have done it a year before Alison. So probably not best place to talk about the essay, but yeah, just reflect what the other 2 said. And yeah, keep an answer grounded in history and context. It's more important in this subject than in most others.
Perfect. Thank you so much, Alison, Amir, and Sam. That will be the end of this session. We'll be moving on to the next segment for criminal law, but thank you so much for all the advice. It was incredibly useful.
Pleasure.
Thanks.
All right, thank you.
Bye, everyone.
Thanks, guys, again. I'm actually doing public law this sem, and I was like literally taking notes as I was trying to concentrate. So moving on now, we have criminal law. And we have Grace and Vivian going to be guiding us through this one. So guys, just introduce yourselves and just start us off with how your experience was with this topic unit.
All right, I guess I'll start. I'm not sure if Vivian's here yet, but my name's Grace. I'm in my 3rd year of my LLB degree. So I did criminal law last semester. Sorry, not last semester, last year, 2nd semester. So exactly 1 year ago. Would you like me to start with the first question first, or should we wait for Vivian?
You can get started, that's okay. I'll just keep an eye on whenever Vivian joins.
Yeah, all good. Okay, so the first question was my experience with the subject. I really enjoyed criminal law. I thought it was a great subject, and to date, it's probably my favorite law subject. And the reason why I really enjoyed it was for a few reasons. The first was the tutor. I had a really great tutor who was really passionate about the subject and just would really tell us a lot about criminal law and its application to current day context. I also had a really great class. Unfortunately, because it is online this semester, it's probably not quite the same experience, but nonetheless, having people in class engage with the tutor, engage with in conversation and engage in debate is always going to make the class a lot more interesting. And the third reason why I really enjoyed criminal law was because the topics there were really interesting as well. It's one of those subjects where you would actually read the case law and be really intrigued and really engaged with what's happening, because the facts are always a bit wacky, a bit fun. Sometimes it can get a little bit overwhelming at times, especially for some of the more sensitive topics like sexual assault. But overall, I had a really good experience with the subject itself. I'll hand it over to Vivian to talk about her experience.
Thank you, Grace. Yeah, so I really agree with Grace. It was one of my favorite subjects in law, and for a number of reasons. I think number one, because it really gets you to think about like how the law tries to fit all these really different scenarios and like crimes into this really discrete set of like legislation. And you really think about like the wider societal context behind crime and like why it occurs and the different elements as well. And every single like topic as well, it's like a mini crime show series in itself. They're like really different, but really like super interesting. And also, I think it's pretty straightforward as well in terms of like content, as long as you stay on top of the legislation, the case law, everything. It's not very difficult to grasp. Like you don't have to think too deeply into it compared to other subjects. So I really enjoyed crim law. It's pretty straightforward, and yeah.
Okay, so just jumping to the next question. So how do you recommend approaching this unit, just in terms of like study or prep methods?
Sure. I can go first if you'd like, Grace.
Yes.
So I think in terms of studying, like the way the course is structured, I feel like it was like 3 main sections. The first 2 or 3 weeks is like the theoretical underpinnings. You learn about like the community welfare principle and the individual autonomy principle. And those like competing theories kind of underlie the entire unit. And then after you look at all of those theories, then you look at like offenses, and that takes up like a good chunk of the semester. And then last is like the defenses to those offenses. In terms of studying, I would say the #1 thing is to like stay on top of legislation and case law. But at the same time, like don't be freaked out if you fall behind. It's like inevitable in law. And if you do fall behind, just like stay on top of the coming week's case law legislation, because it doesn't really link to the previous weeks. Just like park it to one side and then stay on top, listen to lectures. And in terms of like making notes, I would just say like scaffold everything, because with crim law, like for example, if you're doing murder, it just like the legislation tells you what it is, and then there's like the different elements to murder. And then with every single element, there's like a case law behind it, underpinning it. So just make a scaffold, all the different elements, and then the case law relating to every single element. So that's for the final. In terms of the mid-sem, it is a research question. So just try to like remember back to legal research in like your first sem or first year, which no one really paid attention to, but at the same time, it is super useful. And I think crim law is probably the first law subject where you have to do intensive research. So I think that is a bit of a steep learning curve. Like you do a little bit of it for CCP, but I think crim law is like the first intensive one. So I would say just familiarize yourself with like the UCID library website, how to use Westlaw, Lexis Advance, the legal encyclopedias. Another like useful resource is like Parliament research papers. There's like also a website called Judicial Commission of New South Wales, where it kind of looks, you can like Google, sorry, you can search up like offenses, and then it kind of explains the codes behind every single offense. So that's really helpful for the research question. But yeah, in terms of like the actual exam problem question itself, just scaffold everything, make sure you know the definition, the case law, the legislation, and also draw flow charts as well. So one thing with crim law is that like if you think the first most serious offense fails, like murder, then you need to go to like the next serious offense. So like think like a prosecutor and be like, you want to get them for the most intense offense. If it fails, then like what can you go to next? And then like go through the flow chart like that. But yeah, those are my top tips.
Yeah, I agree with everything that Vivienne said. I think the way in which you prepare for the problem question and for the research essay, whether that be the mid-sem essay or the final essay, is going to be quite different. But I think Vivienne's covered most of the basics. I think I can touch a little bit on how to prepare for each class. I'm not sure if it's still a seminar style program or course this year. I believe it is. But if it is a seminar style program, which is what I went through last year, the way I prepared for each class was before seminars, I would quickly skim through the lesson plan that is given to you in the unit of study outline and quickly skim through the cases and the readings in the textbook. And the reason why I say quickly skim is because I was quite busy in second semester of last year, and I'm sure a lot of you are as well. So by skimming through just generally what is happening in the class, that would give you a really good idea of what's actually going on in the seminar so that you're not going to be completely lost, because it's a little bit different, say in comparison to a lecture tutorial style where you have the lecturer say everything to you and you just type it down, and then when you come to tutorials, you more or less know what's going on. In seminars, you don't have that pre-guidance that's given to you. have to proactively do the readings yourself beforehand. So I would definitely recommend at least doing a quick skim through the UOS as well as the textbook readings and the case law, so that you have a good grasp of what the crime is and what the topic is going into each seminar. But as Vivian said, if you run out of time, if you don't have the time to do that, just sort of park it and do it for the next, and I guess for the next seminar, do your pre-readings for that topic rather than focusing on all the cases or all the readings you have like clogged up behind, because everything is quite separate in criminal law. During the seminars then, I would take down the notes that the tutor says that aren't actually written on the slides, because it is all online this year. They're posting everything on Canvas. You're going to have access to those slides, perhaps even before class. So it's not going to be useful literally just retyping out everything that's on the slides. So try to take down the additional points and additional like debates that happen during class, the additional facts that the tutor sort of chucks out during class, because those are the things that are going to be very helpful for your research essay during the mid-sem or even the essay in the final. And often they don't include that sort of stuff on the slides. And in particular, I just want to flag the debates that you guys might have during class time, because criminal law is all about reform. It's all about morals. It's all about whether or not something should be criminalized or the extent to which it's criminalized. And you don't really find that sort of, or a lot of the good ideas that come up in class aren't actually written down anywhere. So be sure to take that down during class. And after seminars, I would take the time to read the cases again in depth, to do the readings again in depth and summarizing it in your own words, because that really just helps consolidate all the information that you get and everything that your tutor has told you in class. So that's kind of how I approached each class. Again, if you don't have time, say for example, you don't have time to go through all of that for the first few topics on murder and manslaughter, and it comes like week 6, don't try catching up if you don't have the time to catch up. Just literally move on to week 7 and do your pre-readings for week 7's topic, and then pick it up from there and then catch up during the UVAC break or the mid-semester break. Yeah.
Perfect. So we just have a question from an audience member. So Sue asks, how do we survive the midterm research essay and actually do well? So do we have any more advice in particular to do with the research essay?
Yeah. Well, I can start with this one. So yeah. I really enjoyed the mid-semester essay, but I think my biggest tip for all of you would be to read the question as early as possible. Even if you don't have time to start it yet, at least read the question, because it's not going to take long. It's a research essay question, so it will be like 1 or 2 sentences max. And the reason why you should read it as early as possible is because that will help you start thinking about it. And it's actually, I'm not sure if it's backed by research or anything, but it definitely, by reading it early, your brain definitely starts to think about ideas for the topic. It helps you sort of formulate theses, sort of ponder about the question, because usually the question is sort of like a morality-based question or a policy-based question. So by reading it as early as possible, you're sort of on the lookout for points of conversation on the news, or points of conversation that just come up between you and your friends, or just any sort of shower thoughts that you might have. And that will help you so much when you actually come to start the essay, even if that's like, say, a few days before the due date or the deadline. Then what I would do after just sort of thinking about it is, when you actually start your essay, I would begin with just doing a whole load of research and just dumping it all into one document. Because that way, that will help you make an informed decision when you are formulating your thesis, as well as your sort of skeleton scaffold, where you sort of come up with 3 to 4 arguments that either support or mostly support your thesis. Yeah, so after all that's done, that's when you can start actually drafting up scaffolds or skeleton scaffolds, and then gradually bolstering it with more information, with more research, with authorities, with journal articles and other readings. But yeah, my biggest tip would just definitely be to read the question as early as possible. You don't have to start it as early as possible, but definitely start thinking about it as soon as the question comes out.
Yeah, I don't have too much to add. I guess this goes to just like generally how to write essays well, right? And I think like preparing is the #1 key, like really early. And also in terms of like where to go for research and stuff, if you have the crim law textbook at the start, I think there is like a list of resources, and then like if you look in the relevant chapters and stuff, sometimes at the end as well there's a list of references, so look through those for like just ideas on like related to your essay topic, and also just in terms of collating research, don't be afraid to like be savage and cut out bits of your research to really like pinpoint your niche idea for your research question. I like when I did my assessment, they gave us a bill on like catfishing, and then we had to like look at relevant legislation. So I don't know if this semester's assessment is really different to that or not. So I can't really speak to like I don't think my experience there will be too relevant, but yeah, like in terms of just generally writing essay tips, like be very specific in what you have to say, and fully explain everything as well. Like I think sometimes when you're writing essays, it's very easy because you've like had all this knowledge immersed into your brain and you kind of know what you're talking about, but park it for like a few days, come back and read it afresh and see if it really makes sense to someone who understands like nothing about the law. Because at the end of the day, when the teacher or the lecturer is reading it, they don't know the context of your research. They're only reading what's on the page. So don't assume they know anything, and just really like articulate your points that way. But yeah.
So our next question, have you successfully spotted an exam question before? Do you have any tips for it, and how would you prepare for it? So more towards the assessments as well. So if you have anything to add that you haven't said before, feel free to.
In terms of spotting an exam question, I would say no, because like at the end, it's a problem question. And so within that problem question, it'll be like a scenario, right? Like a little story of someone who like did something, and then you have to spot all the crimes, whatever. So you can't really predict that, and all the crimes in that little problem question will be the crimes you guys have covered. In terms of like preparing for it, I would just say like, again, going back to what I said earlier about like the scaffolds. So making flowcharts is really useful. I'm not sure the structure of your assessment, but for me, it was like my assessment was over like 2 days, so there was like really no time rush. If it is a short release, then I would say like be very clear on like making your like full set of notes and then a condensed set of notes, so that you have really quick access to them. But yeah, just like be across all the different crimes as well, and know the distinctions as well between like really close concepts like grievous bodily harm versus what's the other one? ABH. I forget what it stands for, but I remember it being really confusing at the very start. So know the distinctions between the different types, grievous bodily harm, wounding, and then ABH,
yeah.
And knowing the case law behind them as well. But yeah, just like be across it, and I don't know, it's pretty straightforward. Yeah.
Yeah, definitely have, oh, sorry.
Go ahead.
Definitely have a scaffold for every single crime, because honestly, any crime could come up. And in fact, multiple crimes do come up in your problem question. And as Vivian said, also have condensed version of like a lengthier version of notes, as well as flowcharts. In terms of the research, sorry, not the research essay, in terms of the essay component of the final exam, because I'm pretty sure there usually is an essay for the final exam, I wasn't able to spot the essay question. I didn't guess it at all. But the way in which I prepared for it was I had 4 to 5 different topics that I prepared a really generic rough essay plan for. And basically in the final exam, that allowed me to just choose, because you do have an option of a few questions for the final essay. You get to choose which question you want to do. Hopefully your 4 to 5 essay plans do cover one of those questions, and then you pick the one that's most relevant and the most adaptable to your pre-prepared essay plans, and then tailor it to that. If you have a long release exam for this semester, which like, for example, 48-hour exam, it's obviously a lot easier because you can do further research during that time. But if you have a short release, so like a 3 to 5 hour or even the 24-hour exam, definitely try to have as many generic essay plans as possible with the relevant quotes from cases, quotes from journal articles, as well as some sort of thesis and debate points that you are familiar with that you can write about in the final exam.
I have one more thing to add. So as Grace mentioned earlier, in terms of like listening out in class debates, I think like just take note of when you get into like a thick debate and there's like no right answer, or there's like a point of law, which is like reforming or like something like that, because those contentious areas are probably going to be essay questions. They're not going to give you like a really straightforward one, right? So take note of that and then think about like your opinion. And I think that's like a good way to prepare for essay questions. But yeah, they can really give you anything. And at the same time, like with the few that they give you, I think there's always going to be one that's super broad and will relate to like the topics that you're covering right now in relation to like the theories, like the overall broad overarching theories of criminal law. So yeah, just be across that.
Thank you. And Vivian, so you mentioned like making sure to distinguish between like ABH, GBH, and like wounding. So would you say there's any more like difficult concepts in criminal law, or like what did you find most difficult about it?
Yeah, good question. I feel like criminal law, personally, I struggled with like the essay question more. So like the mid-semester exam, just because I feel like research questions and essays, it's like more difficult to predict how you'll go versus like a problem question where like if you know the law, you're gonna get, you're gonna pass, right? In terms of like the actual substantive content, I'm struggling to remember, but I think that assault as well, because there's like different types of assault, just be across that. But sorry, this is not a very helpful answer, but I felt like the law in itself was pretty straightforward. Like in terms of a study tip, go to Andrew Dyer's weekly summaries. He makes like a really nice Word doc every single class, and it covers the main points that you need to hit. And then at the end of SEM as well, I think he like puts up not lecture recordings, like recordings of problem questions, of like practice questions. And that like helps me so much in terms of how they want you to respond to a problem question. So look out for that at the end of SEM, but yeah.
Yeah, definitely. I guess I can chip in with some of the topics I found difficult. I definitely found the last few topics in defense is difficult, like the mental illness, SIAM, and automatism. I don't know why, I just could not wrap my head around it. And I think a big reason was because I kind of tried to shortcut it by not doing the actual readings early on. So definitely read the cases properly for those last few defenses, especially automatism, because it is a very unclear area of the law. And yeah, as Vivian said, listen to Andrew Dyer's recordings that which he steps through all the problem questions. Also go through the other PDF lecture slides that the other tutors put up, because that can be helpful for you. You may prefer one tutor's pre-prepared lecture slides over your own tutors, which is completely fine. But definitely make use of those resources in Canvas. And another topic I found quite difficult was the sexual assault topics, because it was so huge. There was so much to cover. There was a lot of readings, and because it is currently undergoing reform, so a lot of things are changing, and you do need to have a good understanding of what the law was and what it is now and where it will be going in the future. So again, my advice for those topics would be to do the readings as well as the journal article readings that are in your unit of study outline. I know Andrew Dyer and Gail Mason both write a lot on that topic and make some really interesting insights in those topics as well that I would recommend you reading. I personally was on call for that topic, so I actually did the readings for that topic, and that really helped me in the final exam, both for the problem question and for the essay component as well.
Thank you. And just one last question for you both regarding hot topic tonight is legal essay questions. So any tips for legal essay writing in general?
I would say just be really clear and like cut your sentences short. I think there's a mistake, or like a common mistake, of just having really convoluted sentences because you're trying to express like complex ideas, right? And have like a really niche argument. And I think sometimes it could just come across as really muddled, or at least that was my case. And like I've had years of experience with like writing essays, and sometimes I still do it. So just like to fix that, I would say like your sentences should never be more than like 1.5 lines. And if you have like more than 2 ideas in a sentence, just chop it. Like, don't be afraid to have super simple, basic sentences. It's so much better than having these like, you can express like, you can have an amazing idea, but if it doesn't come across clearly, then like it's not going to make sense. And like, don't be afraid to just really, have like simple ideas that like build paragraph by paragraph. Also, in terms of like the overall structure, make sure it flows, make sure your paragraphs like aren't too clunky. But yeah, like just be clear is the biggest thing.
Yeah, I agree with Vivian. I think simple is key. And just to sort of quickly address Sanem's question about whether or not it's useful to use theories like feminist theories or Marxist theories to frame your arguments. I guess that is quite a good tip for legal essay writing, to definitely use theories, to use even like journal articles or other arguments that have been well articulated by other people, and using that to bolster your argument as well. But at the same time, making sure that you actually understand what you're saying. So it's no point using those theories if you have no idea what's going on, and if you're literally just copy and pasting and paraphrasing. So definitely argue something that you completely understand and that you have a strong, firm belief in, and then simplify it and explain it as clear as you can possibly do it. And that way your essay will come across coherent, and it will come across as something that it definitely does make a difference if you're just sort of fluffing it, or if you're actually knowing what you're writing about and being clear about it. So yeah, that's just to quickly address Sanem's question as well. But those were my tips for essay writing.
Perfect. Thank you so much, Grace and Vivian. We will be jumping into real property next. So we have Jay Singh and Nicholas. So guys, feel free to just come on and introduce yourselves when you're ready to start.
Do you want to go first, Nick? Or?
Sure. Hi, everyone. My name is Nick. I'm a JD3. So I did this subject, I did equity and real property this semester last year when we were still in person. Yeah, keen to have a chat.
Hi, everyone. I'm Jay. I am LLB 4.5 because I have like 2 semesters left, a bit weird. But I took real property in semester 2 of last year as well, when it was on campus. And yeah, happy to help out for anyone who wants some tips on going through the subject.
Perfect. Thanks, guys. So first of all, how was your experience with this subject?
Yeah, so my thinking about this question beforehand, my experience is pretty mixed. I think it's important when you think about real property and equity that the 2 subjects are really a trio of subjects with IPCL, and the 3 of them are hard to, it's sometimes hard to break apart the links between all 3. So anyone who's doing real property and equity has already done IPCL, and IPCL is a pretty polarizing subject, I think. There are some criticisms about how the course is structured. But I think when you get to real property and equity, you definitely need to re-engage with that subject and treat all 3 of them together. So I think I really loved equity. I had initial difficulties with real property that I eventually mended, but funnily enough, IPCL was a subject that I really struggled with. So they kind of pushed and pulled me in all different directions. But I think it's really important to treat all 3 of them together, and your experience of one will be influenced by your experience of the others.
Yeah, so I'm similar to Nicholas. I did have a mixed experience, mixed because it was hard and difficult to get through, but I also enjoyed the content itself. It's weird to say for real property, but I enjoyed IPCL, and I like how it built on IPCL. I'm taking equity now, and I can definitely see Nick's point on how those three definitely interrelate. I like the application aspect of it in the sense that you learn a lot of legal principles that for any aspiring property lawyer are very applicable, and therefore it comes across, I think in the US, they describe themselves as a lawyer's subject or a practitioner's subject. And it actually does make sense when you go to the concepts. I had done some conveyancing beforehand. So I wish I did this unit before I did conveyancing, would have made my life a lot easier. But overall, I think it's a very, very interesting subject. It's dense and it's rewarding once you get through it in the end. And I found one thing, and I might talk more about it when I give more tips. Basically, it's more mechanical in the sense that there's often more direct answers at the end. Either a person will or will not have an interest in land. And that more mathematical application of it, I think, was a good different point from other law subjects where if you're kind of in the vicinity, you're going to be really, really wrong, really, really right, yet you're still talking about the same issue as the person next to you. Whereas this one, it's less about being in the vicinity of what you're talking about. It's more about getting things right, which is, I found interesting and different from other units in law.
Perfect. Thanks, Jay. So the next question is, how do you recommend approaching this unit? So we're talking study or prep methods. What did you find useful?
So I think one of the difficulties that I had with real property at the start that I didn't realize until I was sort of halfway through the course was that not every topic in the course is created equal. In most subjects, I think you find that like each topic's pretty standalone. Like I was listening to the speakers about criminal law and they were right in saying that every offence is nice and compartmentalised, and then there are all the defences and you can line up all the links in the chain. In real property, kind of ignoring topic one, which is just sort of an overview of how land has evolved over the history. Topic two is almost the whole course. The Torrens title stuff is, I don't think it's an over-exaggeration to say that it's 50 to 75% of the course. Like if you don't understand topic two, then the subject will be a misery for you. And I think when I was doing that semester, I let my knowledge of topic two kind of slide. I thought, oh, okay, like it's just one topic. I'll get to the other. I'll get to it later, the stuff that I've missed. And then I realized later that my understanding of every other topic had to be built on top of topic two. So in terms of approaching the subject, I think you need to crush topic two. You really need to dedicate a lot of time to that Torrens title topic. And then you'll find that each of the subsequent topics are that kind of nice compartmentalized little morsel of law. That's my big tip for approach. What do you think, Jay?
Coming into this, I was going to say the exact same point at the start. It's very top heavy. So the first maybe 2 to 4 topics are very, very content heavy. And the rest of the unit definitely builds off top of that. So in real property, you're basically studying the Torrens system of land as it operates, primarily in New South Wales. And the first 2 or 3 topics are like the core foundation of how real property works under the Torrens system. And then everything else is just a derivative of that. You start getting into more specific legal interests specific interests in land, such as leases, licenses, easements, etc. So definitely start off well in the course, and that will serve you well for the rest of the unit. I think if you start off well and you get the understanding initially, the rest of the course becomes a lot more understandable for you, because the second half of the course is just repeated applications of what you learned in the first half, which is Torrens and stuff. But so the good thing is if you start off well, the back half of your semester will be a lot more beneficial. However, having said that, even the back end can be not conceptually difficult, but be content heavy as well. Towards the end of the unit, when you start learning about easements and etc., there can be there's a lot of cases and a lot of different elements to break down to that. So don't underestimate the end of the course. So usually when you get to the end of the course, you're like, okay, yep, it's like an add-on unit or like the remedy or something when you get to the end of the law unit usually. The back end of the unit is just a little annoyingly a bit too long as well. So remember to stay on top towards the end as well. So those are the parts I found more difficult, of course.
So did you experience any particular difficulties in this unit? So in terms of like concepts, was there anything that stood out as being something that took up most of your time or like was a struggle to understand?
I think in terms of difficulty, so now I've just seen your question about priorities. I'll chat about that. I think my problem with this subject was that I didn't see the forest for the trees. So it's a very spindly subject. Like the rules, and if you read Butt's Land Law, which I think is the text that you should stick with, because the course is really built around Butt's Land Law, you get the sense that real property law is just these, they're not really large broad statements of principle. They're very fact specific, very tightly worded propositions. And I think I engaged with that. And then I realized when I got to actually sort of working out what's going on in a problem question, I forgot to, I kind of forgot that the whole point of the two property subjects and equity is that you need to focus on the transactions that are happening. Like you actually need to focus on the fact patterns in property and equity are quite jarringly different to what you might experience in tort and crime. So in tort and crime, for example, you're looking for someone getting hurt. If someone's getting hurt, then some tort or some crime is happening. And you know that like, that's kind of the focal point of the whole question. You'll know where to apply the principles. When you look at anyone who's looked at an IPCL question, everyone's already done that if you're doing this subject. You'll realize that like the salient features are a little bit more diffused, as in it's not always clear what you're looking for or looking at. So I think it's really important. I had a big like glass shattering moment a few months ago when I was taking succession law as an elective, that like there are, although you have to study the individual bits of the course, equity and property really focus on three different ideas, which is the express intention of parties is one. The second is implications of conduct and words. And then the second is the operation of law to those ideas. That was a system of understanding that I got from a Dalpont textbook on equity. And thinking about it, I realized that like everything in all of those courses can be much better conceptualized. That, by the way, when people get into equity, is the difference between effectively an express trust, a resulting trust, and a constructive trust. When I started conceptualizing all the topics in how they can fit into that kind of taxonomy, everything gets really a lot more straightforward, I thought. So that was an approach that I wish I could have taken if I had that information a year ago.
Yep. I'll try and address both Sinem and Ashwini's question together. So what I found difficult was, like Nicholas mentioned, the fact specificity of this subject. So the subject teaches you to think about, how do I advise a client if this exact situation specifically happens, right? So if it's a different criminal law, so murder, we all know the realms of the Crimes Act are relatively similar regardless, and the elements you look at, regardless of how the offense has occurred. Whereas in here, you need to be able to advise a client on their specific transaction. What are the nuances of that transaction and how does that affect the advice you give? So with the questions, I believe you have mid-semester and a final, and you have, I'm not sure if either of them are short release, but if they're not short release, it's worth taking the time to sit back and revise what the actual transaction is happening. And that's because the assessments I had were, they were usually, you had about a week to submit them. And the aim of this subject is to be able to consider these long-standing and more modern real property principles. How do they apply in these really fact-specific scenarios? And often a slight tweaking of a fact here or there can change the entire outcome. Now, that's more broad in nature. With regards to Cinema's questions about priorities and any advice I would have on this, priorities do form a large part of this course because often you're talking about disputes between different parties and who has different claims to land. So when I found priority disputes to be complex as well, I think it's good to take a step back and think about first principles. So the more complicated things get, try and simplify it for yourself. So what have I learned in class? So for example, you will learn that in order to have a legal interest in Torrens land, which is under the Real Property Act, 90% of the time, subject to very few number of exceptions, you need to have registered interest. And you'll know that a registered interest is a legal interest. And you'll know from IPCL, legal interest usually trumps equitable interest. So if someone has an unregistered interest, you'll know that their interest is equitable. So you start by classifying who's in the priority dispute, what interest do they each have, is it legal or equitable? Then what is the general rule in that situation? So usually legal rule wins. And what are the exceptions, in which case the equitable interest will win? So taking that step-by-step approach and doing one step at a time will help you deal with priorities a lot. And with this subject, contrary to other law subjects, it's not something you try and have really comprehensive, detailed notes on. I'm not sure if this infringes on a future question someone's going to ask, but it's more so about your understanding of the subject and having scaffolds in place whereby you're able to know what you need to look at when a question comes up, as opposed to having like more exam heavy type notes which give you everything you need to know on one piece of A4 piece of paper. The subject's not about consolidating everything into one piece of A4 paper, as is the case for other law subjects. It's about really understanding the subject and how you can apply that to different scenarios. So I hope that trying to address your question.
Yeah, and if I could piggyback on that, I think another important way of conceptualizing these subjects is in contrast to other ones we do. For example, in torts, there's kind of like, there are details that occur before the person gets injured, and then there's all the stuff after the person gets injured. And so you can kind of use the injury in torts, for example, as your kind of midpoint. And then maybe you have like a string of injuries, okay, and then there are like, you can kind of align the timeline around that moment. But you kind of, in a torts question, nothing's happening until someone gets injured. Or in a contract, nothing's happening until a contract comes into existence. And so there's time before the contract and time after the contract. But I mean, the whole idea of property, I mean, the whole reason that we get the Latin root for estate being like something being is because like property is always, that's a very funny sentence to say, but like property at the start of the question, there will be some forms of property probably in existence, and they will be attached to someone's proprietary soul, what we call an estate, and then they will move around. And so you'll part of working out priorities is taking a lens to the question of like, at the very start of time, who has what? And then you need to go down the timeline very progressively and see where all those other things are moving. And that's a very different mental exercise to just thinking, when did the person get hit by the car? Was someone doing something negligent before they got hit by the car? What happens afterwards? So that plays into the priorities question, because you need to know who has what when. It has that fourth dimension.
Definitely agree with all that.
Perfect. Just a final question. How did you guys collate notes for this specific unit?
I thought Jay's comment was really true.
Mm-hmm.
I totally agree. Do you want to go through that again, Jay? I thought expand on that. Yeah.
Yeah. So a lot of you people will be taking real property with equity evidence in corporations, I believe. There may be a few people who are not taking it altogether. What this means, that's a very hard semester for you guys. And one of the hardest to probably do throughout your law degree. And you'll realize your most valuable asset during this period is time itself. And I think where you can save time is in your real property notes. I would spend more time on reading the cases, read them twice if you have to, if you didn't understand it the first time, because you're not going to get stuff straight away in this. You need to be refining your understanding. And I found the best way for me, and it works differently for people, was I would watch the lectures first, get an idea of what the main overall arching concepts are, and then really dig into them and refine them when I do the readings after. So that way my understanding was like, I had 2 goes at understanding something, right? And the readings, the case law judgments often give really good explanations of what you need to understand. And that makes it very clear for you. And from there, your notes should be more about, if I see this issue in a question, what exactly do I have to address from that? So for example, if it's an easement, there's 4 requirements for an easement. So if I see something that looks like an easement, I need to look at 1, 2, 3, 4, and are all of them ticked off. So if it comes up in the assessment, I can go back to my cases and my lecture notes and stuff and really apply each one methodically. It's not something like a contract law exam or even IPCL or certain topics where you can kind of condense it all into on one A4 piece of paper. And then if that comes up in the exam, you can just reference that A4 piece of paper and then synthesize that and paraphrase it into an exam essay question. It's not that type of subject. So you can actually make your life easier for yourself by having less detailed comprehensive notes, but which still address everything you need to talk about. So you're not missing anything in case a particular legal issue comes up. And that will save you time. That'll help you manage your workload at other subjects. So I'm pretty sure a couple of the other units you'll be doing this semester do require more comprehensive notes. So you can have that trade-off and give yourself a bit more balance there. That's main advice I have.
Thanks, Jay. Thanks, Nicholas, as well. Osanem has just posted. Oh, it's another question.